Viewers, welcome to Personal Injury Law Show. This show talks about everything current in the law of personal injuries. My name's Tony Carbone. I'm a personal injury lawyer of over 30 years' experience. With me tonight, I've got an accredited specialist and partner in the law firm in workers' comp, John Karantzis. Good evening, John.
Hi, Tony. Hi, viewers.
And Nardine Hanna, an associate and branch leader in a law firm in workers' compensation. Good evening, Nardine.
Hi, Tony. Hi, viewers.
Tonight, viewers, we're going to be giving you an update on the workers' compensation system. We've got a new act coming in on the 1st of July, so stay tuned for that.
However, Tony, what's in the news?
There's been a lot of stories in the news. One that's very interesting, John, this is right up your alley. There's a Royal Commission into the use of union funds.
Oh, yes.
Tell us a bit about it, John.
It's Commonwealth Government, the Abbott Commonwealth Government, Tony, they're looking into, and it's a Royal Commission, into what happens with union funds and the way they're spent. And as we know, Tony, we've got a situation where even former Prime Ministers are being looked at.
Okay.
Julia Gillard, and what happened over 25 years ago with monies, slush funds. There's allegations of slush funds. There's monies going basically for purposes that they're not supposed to go for.
And Nardine, what's really interesting about this is that if you're a worker, you're effectively forced to become a member. So you do want to know that your money's being used wisely, don't you?
Well, that's exactly right. I mean, we have these workers that pay these fees annually to the unions for, particular perks as part of the union members, Tony. So I think there's a lot of media and a lot of attention that's probably well needed, given that what's been happening in the splurge and the funds accordingly to these.
We've got a situation where the former union boss of the HSU, Kathy Jackson, is being examined now in regards to her use of the company, the union credit card. We've got over $1 million in expenses, it's been alleged, that have been claimed by Kathy Jackson, and that's been looked at very closely by the Commission, Tony. It's very important, isn't it?
Yeah,
Tony?
I think so.
Because we've got hard-working workers that are paying union fees.
And where's the money going?
And where's the money going?
Exactly.
It's supposed to protect workers.
The underdog.
And apparently that's not the case.
Not the case. Yeah, look, we'll come back to this, viewers.
Yes.
What about this accident that happened the other day? Well, down in Phillip Island, Nardine, you said you couldn't get there on time, and now I can see why.
Well,
There's two guys with drag racing.
That's right. There was a massive blocking off on the South Gippsland Highway, and it seemed that there was a drag race and a young girl of, 19 or so that's in hospital.
Fighting for her life.
Fighting for her life.
Yeah, she probably won't survive. Who knows?
It just goes to show again, and we repeat this all the time, don't we, Tony? On the roads, it's not a racetrack.
No.
It's, and it's, we're talking about 18 and 19-year-olds.
The babies.
In fact, when you go on the road, you're really taking your life in your hands every time you're on the road.
So
in fact, the statistics are that there's less plane crashes, there's a greater chance of getting injured in a car accident than a plane crash.
Well, that would make sense, wouldn't it?
Yeah. Just following on from this story, I want to take you to another story, guys, where a champion skier who wanted to compete in the Olympics was a passenger in a car driven by his friend. He crashes the car, his friend walks out with literally a scratch, and he's rendered almost a quadriplegic. Now, he's no longer his mate, John.
No, and he looks like he's got a pretty substantial claim, doesn't he, Tony?
Yeah, he has.
Yeah.
And Nardine,
yes,
you can sue friends and family in car accidents?
Well, there's no friends in car accidents anymore, is there, Tony? And it seems like this gentleman is now going for claims for damages that could have been and potentially awarded to him, because, he's been saying that I could have gone and skied on and
he said he would have got prize
further
money.
amount,
He
of
alleges
prize
that
money.
he would have been skiing at the recent Sochi Olympics.
That's
Yes.
right.
He could have become a champion and moved on and, won the glory, won the money. That didn't occur.
Yeah.
There was a substantial injury. He could not compete at the Sochi Olympics. However, he did work there, assisting another Paralympic competitor, Tony. So that sort of reduces his economic loss claim, doesn't it?
Yeah, it does, but he says that he's missed out on substantial prize money, and also he wants to get into sports management and high performance coaching and things like that. So he's lost that opportunity.
Yeah, and it'll be interesting, I think, to see how we can quantify that in the future for him too,
It's
because
hard.
it will be almost untapped, wouldn't it?
It really depends. You have to look back at how he's progressing before his
That's
injuries.
right.
Exactly.
That's right.
All right, we're still on the subject of cars. Now, this is a very touchy subject, viewers. It says that older drivers risk lives in unsafe cars. Now, there's a view out there, Nardine, that older drivers are generally more dangerous because their faculties aren't quite up to speed.
So, Tony, are we talking about the older drivers being unsafe or the unsafe cars being unsafe?
Well, there's two parts to this story. The first one is older drivers, right? Their faculties are a little bit down, eyesight, hearing, etc.,
Well, I
reflexes.
suppose it's perception and reflection.
In the end, as long as the GP, the doctor, certifies them clear, an older driver, that yes, you're healthy enough to drive, what else can we do, Tony?
But they do say in this article that a lot of accidents that older drivers are involved in, they walk out with worse injuries because the cars are older, so they haven't got the airbags.
Oh, okay.
They don't have the where the car collapses on impact. So you've got that bang, massive trauma, and it caused a lot more serious injuries.
Yeah, you'd rather be in a car accident in a brand new Commodore than an old Tirana.
It's true. And Sam Cofield, the TAC road safety manager, says the increase in older driver accidents and severity is due to the ageing population. That's in some part too, isn't it, John?
Yes.
Oh, yeah, that's
Yes.
right.
So maybe we
Right.
should have discounts, brand new car discounted for older drivers, Tony.
Pension discounts, John, maybe.
A lot of them don't like giving up on, they're very, very particular
Attached to
about
their
attached
car,
to their
And there's
cars.
equally, I suppose, a sense of real independence for these elderly drivers as well. So it's a real delicate type of topic that's happening in the media.
Now, Nardine, 1st of July, we've got this new legislation coming in that's supposed to be simpler, and John will tell us that the Act is thicker than the old one. So how's it simpler?
Well, you've already told us that, Tony. So, yes, that's correct, Tony. 1st of July 2014, the new WorkCover laws come into effect in Victoria. Apparently, it's supposed to be simpler. There's flowcharts in the new Act, Tony.
Flowchart?
Flowcharts. It's like pictures for the client, so we can show to the client, this is how the system works. Yeah. So they've tried to make it simpler. However, there's an issue that the new Act is actually thicker than the old Act.
Oh, wow.
So
That's insane, isn't it?
And on top of that, Tony, the numbering is totally different.
It's going to be a minefield for
So
once when it comes around.
lawyers
the 1st of
and
July.
barristers alike have to relearn all the numbering from the old Act to the new Act.
Before we go to the break, this is up Johnny Karantzis.
Oh, yes.
Definitely.
I like it.
Anton Peruzima, 62, bitten by a dog in New York, is suing for about $20 trillion.
Well, it's $2 undecillion. $2 undecillion.
I don't know what that means.
It's 2 million, 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 million.
Is that even a word? Did they just make that up for the purposes
Yes,
of the...
2 undecillion.
Is there a fair chance that you won't get anything at all? Because, the jury would laugh this off.
Oh,
wouldn't
I would think that if I was a member of the jury or if I was impanelled, I'd probably sit there.
they? Viewers, we're going to go to a sponsors break. Stay tuned. The next segment is relevant to you because we're talking about updates on WorkCover. welcome back to the show. Tonight's episode is an update on the WorkCover system. In particular, we'll take you through a few cases that are very, very important. Nardine, the first case is a matter of Victorian WorkCover Authority versus Centro Property Management. Now, this is a lady that was injured working as a security guard. Can you give us the facts of the case?
Absolutely, Tony. So this is Amanda Taylor is the plaintiff in the case. So even though, interestingly, she's not named in these proceedings, but we'll explain a little bit later why.
Yes.
Now, she worked part of a security group and located at the Centro Management. So it's kind of like a shopping centre.
Yep.
And in the course of her employment, she was required to erect these type of mesh barriers every morning to be able to prevent, public entrance and and secure off particular areas. So I think it was the 1st of March 2009, Tony.
Yes.
Amanda was required to set up these steel mesh barriers, and it seemed that these mesh barriers had fallen and toppled over her, and she had sustained quite serious injuries to the shoulder, Tony.
Okay, before we get to that, John, traditionally at law, the reason why this case is significant is that at law, when you've got contractors working for a larger group, usually on building sites, the independent contractors generally got to look after their own well-being. Is that correct?
Exactly, Tony. They're specialists, they're expert in the area. Usually the contractors are in control of the system of work, so they're responsible for their own workplace.
Exactly. And also the supervising contractor or party generally doesn't have the expertise that the contractors have got.
Exactly.
To actually provide them the duty of care, like electricians and that.
That's right, Tony.
Nardine.
Yeah, that's right.
But significantly in this case, who set up the system of work, John?
Well, yeah, this is where it gets a little bit tricky. Centro has engaged a security firm to provide security guards. Now, the security guards work at the shopping centre, and Centro, who controls this shopping centre, have basically instructed the security guards on what to do and how to do it. In this case, regarding these big mesh barriers. Now, we're not talking, small 1 metre barriers. We're talking very high, heavy mesh barriers, Tony. Now...
Well, they were 40 kilos, and just on that point,
Yep.
Nardine,
Yes.
each morning I had to unlock the 2 steel mesh barriers, which were locked together at the point at which they met, then fold them inwards in a concertina folding movement. Then unlock the other end of the steel mesh barrier from the wall and then wheel the folded mesh barrier to a different part of the premises where it was not in the way of the customers.
So
40 kilos.
That's right. It's
And you
very
go like this.
heavy.
Yeah.
It's very arduous. There was a lot of evidence that was coming out in the course of the trial that said that these mesh barriers even had a propensity to fall over, Tony.
Yes.
So these were quite risky and quite risky objects to be able to manoeuvre around.
Exactly.
And Centro had basically organised this system of work, had directed the employee, as in Amanda Taylor here, to perform this work, and as part of the evidence that came out in the finding.
John, stop there for a minute. So Centro, the people that were running the shopping centre, actually instructed her on how to carry out that task.
Exactly.
Correct?
Yes.
So-
Yours, that's the key to the case.
It was really under the control and the practical management of the third
Yes.
party, wasn't it,
Yes.
Tony? So that was
Yes.
a real key feature in this case.
And also, John, in terms of having to do that task, it was a bit difficult for one person, wasn't it?
Yes, exactly. We're talking about a heavy piece of, a barrier that the worker had to try to open up and close every morning. Now, whilst doing that one day, it's literally fallen down.
Yep.
As it was falling, it's caught the worker's arm, pulled her shoulder and back.
Yep.
And she has sustained serious injuries.
That's right.
And also, Nardine, John,
Yes.
what's significant is that a few weeks before she got injured, the whole system was very unsophisticated. Approximately 4 to 6 weeks, Mrs. Taylor accident, there was a complaint about one of the barriers being bent or buckled. The Centro addressed the complaint by putting a barrier on the ground and standing on it to bend it into shape.
It's all haphazard.
Very unsophisticated, isn't it?
They were saying in the course of the case, even Justice Bell was making commentary that this was really an accident waiting to happen. And it should have been really quite foreseen by the Centro group that these barriers were not adequate to be able to, be fit by one person, adequate at assistance, and there should have been some way to be able to manoeuvre and change these barriers across to be able to...
And it was reasonably foreseeable,
That's
and
right.
the judge said it was an accident waiting to happen.
That's
Exactly.
right.
Mr. Dorman, an engineer engaged by the plaintiff, said that barriers had a propensity to fall over given its design, and the unsophisticated and quite silly evidence given by the engineer for Centro, Dr. Colviner, was that the stability of barriers was adequate. Was clearly not adequate when people are falling over.
That's right.
We've got two engineers at different viewpoints, Tony.
Exactly. John, what about the fact that during the trial, Mrs. Taylor gave two different versions of how she got injured?
Yes, look, and the defendants attacked her credibility in that regard, as in, she's giving slightly different evidence from the stories she had given earlier. However, Justice Bell, in his written judgment, said, look, given that it's over 4 years from the date of injury, I've got no doubt to doubt the credit of this witness, and it's almost normal, it's almost natural that she would not give an exact version of the event the second time and the third time and fourth time and fifth time.
And Justice Bell was also saying, actually, wasn't he, John, that she was alone at the time as well. So
yes.
I suppose her perception and her recollection of the events might be, a little bit hazy given the time in the events that had happened.
Nardine, what I'd like to highlight is that notwithstanding the fact that her versions varied, she must have been a pretty honest and reliable witness, because if they had shown video to contradict her veracity and credibility, that little bit of evidence could have been damning, don't you think?
It would have tunged most of the claim,
Yeah.
There's a lot of damage that would have occurred.
Exactly.
And the judge gave a nice simplistic view of her memory. He said, I think it's very understandable that her memory is a little hazy about what precisely occurred. That's well put, I think. Albeit, more often than not, John and Nardine, you and I know that a lot of people do lose cases based on their recollection of events.
Right.
What really is the crux of the matter here, His Honour found that this was an accident waiting to happen.
Exactly. But having said that, Nardine and John, haven't we also got a situation that the security company still had a non-delegable duty of care to the worker?
That's right.
And so the judge did come back and blame them 25%.
Well, that's right. And I think that's quite significant in the sense of this case, because even though Centro had been awarded 75%, and that they're definitely in the gun, 25% still for an employer relationship is, quite high in the given the facts.
Well, the employer should have ensured that Centro was doing the right thing by its workers.
That's right.
And that's why they copped 25%. Viewers, don't go away. After the break, we're going to be talking about what is considered appropriate compensation when someone sustains a back injury in Victoria. Stay tuned. Viewers, welcome back to the show. Before the break, we were talking about what is the right price for your injury. Now, this is very contentious, John, because we've got a lot of cases where clients come in and say to us, my friend got 300,000 for the back and I only got 50. No case is the same, and this highlights that fact. Now, Nardine, tell us the facts of Geelong Lever and Michael Delaney, 2014 decision.
That's right.
Of the Court of Appeal.
So that's right. So this is a decision coming from a jury verdict, Tony, and this particular worker he was stacking hides, as we know it, with another employee, and as he was lifting and manoeuvring these hides, had felt some pain in his back, and it showed later in radiology that it was quite a significant protrusion. And he later went on and had surgery to his lower back. Isn't that right, Tony?
Yep.
So we're talking about a person that's had back surgery
That's right.
from a work injury. He's not working and he's suffering a lot of consequences.
That's right, and there was even, it's probably worthy to note that there was proposed second surgery, although the plaintiff in the case, or the respondent I should say, wasn't interested in having that
So the
second lot.
surgery's basically failed
That's-
and he's still having ongoing problems.
That's right.
The other thing that's relevant and highly important in this case, Nardine, is the claims only for pain and suffering and loss of enjoyment of life job.
Yes,
There's no loss
economic
of income.
loss.
Yep.
And-
And that's highly important.
That's right.
Yep.
And now
That's
we know
right.
in Victoria, Tony, that the cap on damages for pain and suffering is $555,000, and that's usually reserved for someone that's a paraplegic, tetraplegic.
Quadriplegic,
Exactly.
brain damage,
Yes.
that sort of scenario.
Now, interestingly, Tony, in this case, it was only an assessment. The jury only assessed the case for the monetary value, as in the defendant said, yes, we are at fault.
Yeah, they agreed to
That's interesting.
liability.
That doesn't happen too often.
We concede that
Yep.
we were wrong. We did not provide a safe workplace. Basically now the jury were simply asked to look at the evidence on what the pain and suffering consequences of the injury were to the worker.
Nardine, what was really important in this case was there was video surveillance. Viewers, video surveillance, don't forget this. What did the surveillance show, Nardine?
Well, it showed that this particular worker had been bending over in a car after he'd given evidence that he had extreme difficulty manoeuvring and bending over with his back. Wasn't that right, Tony?
Yes, and it showed him recoiling, or not recoiling or grimacing
That's
with pain. He then said, John, this is the best part, I love this, it was wrong for him to suggest to the jury early in evidence that on the majority of occasions when he leaned forward or bent down to pick something up, that he'd get a twinge down his right leg. He said the honest answer would have been that I've got good days and I have bad days. The jury loved that.
So he corrected himself.
Yeah, he corrected
He
himself.
initially was exaggerating the amount of pain.
It was embellishing.
And
yeah.
then I think he was shown the video, what the reality is, and he sort of corrected himself and said, yeah, look, there's some days that are good, some days that are bad.
That's right, yeah.
And Nardine, he would have put himself out to the jury and said, members of the jury, I've overcooked it.
Yeah, and I think it's a real testament to this gentleman's character. Look, albeit that he was probably getting a little bit too excited with the extent of his back, but we appreciate that his back was of quite considerable damage. But he peeled it right back and he was a bit forthcoming in the sense. But did he have it was probably forced into a corner to be able to say that, I suppose.
Yes. So, Tony, the real question here is $385,000. Is that too much?
Well, exactly. He's young. That's important. He says there's a lot of things he cannot do. The running, he has difficulty walking, he's on painkiller medication. It's affected his sport. He can't engage in the domestic duties he used to do beforehand, trouble sleeping. But what the jury had to look at was the damages, perverse, manifestly excessive, or not open on the evidence. And the Court of Appeal said what, Nardine?
They said no, it was open for the jury to be able to find what they had found, which was $385,000.
And John, of interest too, the appellant, the WorkCover Authority, put up 6 other awards of pain and suffering damages involving backs to compare.
Which weren't as high.
No, but the Court of Appeal said no.
Well, the Court of Appeal said, look, each case has to be considered on its particular individual characteristics.
Exactly.
And there was not enough to overturn the decision of the jury in this case. However, well, firstly, the Victorian WorkCover Authority, Tony, they thought it was perverse and manifest, didn't they?
Yes.
They thought it was just simply too much. I have to admit, it is on the high end. Actually, that's what the court found.
Look, it is on the high end.
The court found this is on the high end.
That's right.
Yep.
However,
There's no reason to overturn it.
Exactly. And we had the president, President Maxwell, determining this case with also Justice Beach and Justice Kuru, Tony. So we've got the 3 eminent common law judges in the Victorian Supreme Court, Tony. Well, did they get it right?
This is a caution I'm going to put to the viewer. Be careful because it's one out of a box. Very rarely does anyone that doesn't have a quadriplegia or /paraplegia get an award for pain and suffering this high, John, especially for a day. Very rare.
I know the attitude of the Victorian WorkCover Authority. It's different, isn't it, Tony?
Exactly. The other problem too, Nardine and John, is that to get this award, the plaintiff would have had to run the case for at least 5 days.
Yes.
And so the plaintiff would have lost possibly 100,000 in fees.
The legal
at least.
costs,
Extortionate.
out of pocket
Horrendous.
expenses could easily be $20,000 a day.
Exactly. So that's another thing for the viewers to bear in mind. Just let's quickly go to this other case because time goes, as we all know.
That's right.
Pekin Engineering and Victorian WorkCover Free and Mackenzie John.
Tony, this is a case where the worker has sustained a left-hand crush injury in 2004, and then in 2008 he sustained a left knee injury. Now he settles his 2008 left knee injury for a lump sum, and now he's gone to court claiming compensation, lump sum compensation for his 2004 left-hand crush injury.
And you have to disentangle at law, Nardine, the consequences of the one that you've settled.
That's right.
And the consequences of one that's ongoing.
That's right. So it's a real comparative analysis between the two types of injuries. It doesn't make sense necessarily in the eyes of the court that if you've got the same consequences overflowing between the 2004 and 2008, albeit they're probably different type of body parts, Tony, it's a very, very cautious analysis at that stage as to what is happening in the worker and what is the complaints of pain, the pain medication that the worker is taking, and how it's affected and changed his life in those circumstances.
Well, sadly for this plaintiff, the fact that he had problems shaving his head, gripping items such as coffee cups or beer glasses, difficulty changing gears in a manual car, the court found that the injuries weren't serious.
Exactly, Tony.
As according to the law that we operate under in Victoria.
They weren't serious or marked.
It wasn't significant.
Exactly, Tony. I think, reading between the lines, Tony, it looks like to me that the court wasn't really satisfied that his injuries sustained in 2004 had a really bad effect on him.
Yep.
And he kept on working afterwards, and he received money for an injury that occurred 4 years later. I have a feeling, Tony, just reading between the lines, that the court wasn't satisfied that the 2004 injury
was that
met the threshold.
That's right. Yeah, that's right.
Nardine, I want to thank you for coming on board.
Thank you,
John,
Tony.
As
Tony,
always, thank you.
Thank you.
Viewers, go to our Facebook and Twitter and give us all your comments. Stay tuned for future episodes. And also, I'd like to dedicate this episode to my father, Giuseppe Carbone, passed away a year to the day today. Dad, rest in peace. And viewers, on that note, stay tuned for future episodes and remember to stay safe.